Guys to my YouTube channel Tahir Tag. Today our topic is Houston Maritime Attorneys. We serve injuries maritime worker nationwide offices in Texas and Louisiana. Just like any other industry, seamen are at risk of suffering work-related injuries anytime they are on the clock. The court recognizes this and are continuously working to protect injured seamen through general material law. Maritime law gives workers who have been injured offshore or in the maritime industry the chance to claim necessary compensation for any suffering of medical complications. The following acts are foundational to maritime law: Jones Act, Death on the High Seas Act, Limitation of Liability Act, Longshoremen and Harbor Worker Compensation Act. General maritime law is the basic for all injuries sustained by seamen. It is important to have a comprehensive understanding of the general law before delving into the subsequent act. How to choose the right maritime injury attorney? Maritime law can be complex, although these laws are designed to protect the right of maritime workers who become injured or ill. They can be difficult to navigate. This is why it's crucial to seek legal representation from an attorney who has a deep background in this era. Of the law, it is essential to select an experienced maritime lawyer. When choosing an attorney, you should inquire about the number of maritime cases they have tried. Don't allow an attorney to dance around your questions. You need to select someone who is prepared to give honest, direct answer to all of your inquiries. The basic maritime law. Maritime law is derived from many sources, including federal statutes and general maritime law. These sources provide some of the maritime doctrine that are commonly used in cases involving vessels and their passenger crew. Maritime law sets forth many of the basic legal tenets associated with the seas and seamen's, including seamen's right to maintenance and cure. Maintenance and cure refer to the benefits a seaman is entitled to until she recovers and is fit for duty. However, there is a maximum medical improvement limit that can control the amount of compensation received. Maintenance, including such expenses as the seaman's rent or mortgage, utilities, property taxes, homeowner insurance, and food. Cure is similar to worker compensation benefit for employees. It's cover costs related to medical treatment for the work-related injuries. A seaman is someone who is a captain or crew member aboard is a visual in navigations. Also similar to workers' compensation, maintenance and cure does not require that the seaman prove any fault for their injury. The employer is required to pay. The Jones Act. The Jones Act is a federal law that gives seamen to a statutory right to sue their employer for personal injury damages. However, a seaman must spend at least 30% of their time working on a vessel to qualify for the Jones Act. Not only does the Jones Act provide the seamen a statutory right to show their employer, it also eases the burden of proof needed to prove causation between the employer negligence and the seaman injuries. Under the Jones Act, the employer negligence only need to play a part in the seaman injuries rather than being a proximate cause. The Jones Act also incorporates aspects of the Federal Employment Liability Act. In particular, claims filed in state court under the Jones Act are not removable to federal court. Thank you for watching video. If you like my video, please press the bell icon and also subscribe my channel for the future video update. Thank you.